Good afternoon. My name is Alina Shautsova. I'm an immigration attorney from Brooklyn, New York. In today's Legally Speaking seminar, I would like to talk to you about 5-year permanent bar that is applied to those who did not come in for their immigration court hearings. The law states that if anybody without reasonable cause does not attend their hearing, for 5 years they will be inadmissible after they're removed or if they depart the United States. So it's very important to know that this bar will be applied to those who left the United States and are left after they failed to appear in court for their hearings. That's why it's so important to appear in court for your hearings. Unfortunately, there is no waiver for this bar, but if you can demonstrate that you had a reasonable cause why you missed your hearing, you may be granted discretion for this bar not to apply to you. The law is such that it doesn't really say to us what is reasonable and what is not, so it will depend on circumstances. For example, of course, the government first has to show that you received the notice. How does it show that? Well, maybe the notice was given to you in court. Perhaps it was mailed to you. If it was mailed to your address on file with the court, then there is a presumption that you received the notice. If you moved but didn't tell the court, it will be your fault that you did not receive the notice. If you filed a motion to change of venue but did not receive a decision on the motion and decided not to come to court, again, you will be found in default. If your excuse will be that there was traffic on the way to court, if your excuse will be that you misplaced the notice, you did not know where it was, if you would say that your lawyer didn't tell you where the hearing is, most likely it will be your fault. With lawyers, there is a special exception. When the lawyer does not tell you when your hearing is going to be, and the lawyer was supposed to tell you, and only the lawyer was in control of the notice, let's say you didn't receive a copy of the notice. If you comply with certain requirements by the law, you may be able to show that it was not your fault. Okay, so that's only one exception. So how this issue may come up? Usually it would come up if you were in the United States and let's say you received an I-601A waiver, okay, and previously to that you received a waiver for your default order of removal as well, and now you're going for the visa and your lawyer didn't check, didn't talk to you about why you missed the hearing or you were not prepared, maybe something else happened, and during the questioning in the consulate, the consul will ask you questions as to, so listen, I see that you missed your hearing and that's why you had a default order of deportation, so why did you miss your hearing? And you would say, well, I was scared because, my friends told me not to go. So your waiver that you just received, or 2 of them, will not help you, okay? You will be found inadmissible for failure to, without reasonable cause, to appear at the immigration court hearing. You also have to take this into consideration when you are thinking about the waivers. The good news is that, or semi-good news, is that this bar applies to those who were placed into removal or immigration proceedings after April 1st, 1997. Okay? So before that, if you received your order of deportation a long time ago, this bar will not be applied to you. So in every case, when there is a default order of removal because you didn't show up for a hearing, you need to talk with your lawyer about possibility of this issue. Now, if you reopen your case right, and try to fix it here without leaving the United States, then you will be okay. This bar will not apply to you. And you can read more about the waivers and various inadmissibility situations on our website, www.shaltsova.com. Thank you.